Thank you for joining our webinar, ICANN63 Recap, Updates from Barcelona. My name is Brian Costello, Marketing Manager for MarkMonitor, and I'm excited to be joined by my colleagues, Staten Hammack, Vice President of Global Policy and Industry Development, and Brian King, Director of Internet Policy and Industry Affairs. So without further ado, I'd like to welcome Staten and Brian to our presentation.
Thank you very much, Brian, for that introduction. Welcome, everybody. It's good to be with you. Thanks for your attention as we roll through our recap of ICANN's last meeting in Barcelona that occurred last week. You'll see from the front page of the presentation that we mentioned that ICANN turns 20, and that's a reference to them actually being 20 years of existence. And so a number of celebrations and recognitions took place in Barcelona to commemorate 20 years of ICANN being one of the stewards of the internet responsible for the security and stability of the domain name system. So we were happy to be a part of that. We have quite a bit of content we'd like to cover with you, Brian and I. So here's what our agenda will look like for the next 40 minutes, after which we'll have plenty of time for questions and welcome questions from everybody who's participating in the webinar today. We're going to go through just a few quick facts of the event itself, and then we're going to tackle, of course, the biggest topic, I think, and the one which required most attention and focus by participants, and that is GDPR and WHOIS. It's still the biggest topic at ICANN. But after we get through that, we'll also brief you on other policy work that's happening that is also equally important to our clients and those of you who are on the webinar with us today. We'll cover off on a few other major topics of of interest that I think folks will be pleased to hear about. Go again over how to get involved and then the questions, as I mentioned. So let's get right into it. I'd like to always begin the webinar with reminding everybody why MarkMonitor is present at ICANN and what our objectives are there. First is to advocate on behalf of our clients' intellectual property rights, as well as to encourage policies that enhance consumer trust and safety on the internet. We also are actively participating in policy development processes. As a corporate domain name registrar, we are active in the Registrar Stakeholder Group. We're also active in the business constituency and the intellectual property constituency multi-stakeholder groups at ICANN. And so that is where we do a lot of our heavy lifting. But we are also there to meet with ICANN staff, strategic partners, supporting organizations, other leaders, governments, law enforcement agencies, and any other group who has an interest in protecting the internet and intellectual property rights and security and stability. And so we make a great effort to meet with those individuals in those groups as well. My team at ICANN this year consisted of 5 members: Stu Holman, Sherry Hildebrand, Prudence Malinky, Brian King, who's on the webinar today, and also MarkMonitor's president, Chris Viator, was also at ICANN to contribute. So here are the quick facts. The meeting was in Barcelona. It was extremely well attended. Approximately 28 people were in attendance. I think that's largely attributable to the attractiveness of the host city. Barcelona is a beautiful city with a lot to offer the participants there. It was a 7-day meeting format since it was the annual meeting, which includes all of the general information sessions, policy meetings, constituency and stakeholder group meetings, community outreach, and 2 public forums where people could address concerns and ask questions of the ICANN Board of Directors. As I mentioned, sessions with the highest attendance and participation and interest, GDPR, and the ongoing policy development work related to the temporary specification for registrant data, which Brian will speak to in just a minute, replenishment of ICANN's reserve fund, Subsequent Procedures Working Group. This is the group that's working to identify what changes should be made in the application process for new TLDs going forward. And of course, GAC sessions are always of interest. GAC is the Government Advisory Committee to the ICANN community. It's made up of government representatives who share advice and concerns regarding the DNS. Their sessions related to geographic names in the top level and at the secondary level always brings some interest from the ICANN community. So we're going to jump into GDPR and who is the current status. Just to level set everybody, GDPR became effective on May 25th, 2018. At that same time, ICANN issued a temporary specification for registrant data, which was ICANN's attempt to come up with a policy for the display of WHOIS data by registries and registrars that it believes would be GDPR compliant. But as a result of that temporary spec, what we saw is many registrars and registries redacting the registrant data, including the name and email address, phone number, anything that was related to the registrant information. So it's no longer publicly available in WHOIS. If those of you who have tried to do a WHOIS lookup search post May 25th, what you're seeing is a fragmented patchwork of different outputs, and some data being redacted, other data not being redacted, depending upon what the registrar and registrant wants to do. And that is creating, of course, a lot of challenges for those of us in the brand protection business and intellectual property protection business, because we had historically relied on WHOIS in order to identify where the infringers are. We saw at this ICANN meeting a number of reports from cybersecurity experts and brand protection companies, including MarkMonitor, sharing what these impacts are to the ability to do brand enforcement and consumer protection. So that was of interest. ICANN has proposed a unified access model at this point. A framework for such a model, not a fully fleshed out detailed model related to the non-public WHOIS data. And I'm going to be speaking to this in a few minutes after Brian gets through the temporary specification work. But this is very interesting, and will have will be a long-term project for the multi-stakeholder community, coming up with a way to access non-public WHOIS data. And finally, what's been kicked off subsequent to GDPR is the Expedited Policy Development Process for the temporary specification. And as I mentioned, this was one of the largest, most focused groups working at ICANN63. Brian King on our team is an alternate intellectual property constituency representative to the EPDP, which means that he is spending quite a bit of his time during each week involved in this policy development group, which aims to finalize the temporary specification into final policy that can be adopted by the community for WHOIS display. So to get into a few more details, I'm going to pass it over to Brian so that he can walk everybody through what is happening in the EPDP and where he expects it to go in the next few months. So Brian?
Sure. Thank you, Staten. And you importantly noted that the temporary specification was the ICANN board's attempt to solve in the short term the problem of WHOIS data access in a world where GDPR prevents the unredacted publication of all domain name registrant data. And ICANN should operate and does operate in a multi-stakeholder governance fashion. And so a top-down unilateral ICANN board action is the exception to the rule and may only apply for the short term. And long term, what the community is doing is undertaking this expedited policy development process to decide how WHOIS data should be displayed, requested, processed, and managed going forward. And it's a great deal of work in a short period of time. Typically a PDP that the GNSO initiates takes years and years, and then there's implementation time and implementation reviews, and it does not happen quickly. But we only have a short period of time because the temporary specification expires within a year. We need to get policy done within a year to make sure that WHOIS data can continue in some way, shape, or form into the indefinite future after the temporary specification expires. So what the EPDP team has been doing is looking at the purposes for processing WHOIS data, and the GDPR requires this type of start at the beginning analysis of why are you collecting the data, why is it being processed, for which purposes, and then you need a lawful basis for processing the data. And so we've really had to rethink the whole concept of WHOIS. And there are good registrant protection mechanisms for processing WHOIS, right? It helps you prove that you own a domain name if there's some database that ties your personal data to the domain name. There are some good registrar purposes for making sure that registrars know who their customers are, and there's some database to prove that. And there are some good reasons like intellectual property protection, helps to file a suit under the ACPA, for example, in the US, if you can find out who the registrant of the domain name is. So, so we've gone through the purposes for processing data, and we've agreed on those purposes in principle, and there's some horse trading going on to finalize one or two of the final purposes, but that was a big accomplishment in the Barcelona meetings that the EPDP team finally decided on purposes A through M. There are a lot of purposes for processing WHOIS data, and so that's nearly concluded now. I should note that there will be implementation time after the EPDP team decides on what the policy is. So policy in ICANN happens in a multi-step manner, the first of which is that the policy is developed and then it must be implemented. And there's an implementation review team that needs to manage that implementation, and that is not going to start until after the policy is done. So we're still far from the end, but the team is making progress. And another hot topic that was mentioned in Barcelona and actually discussed in depth was the difference between reasonable access, which the temporary specification requires, and standardized access, which is a concept that you'll tackle later in the unified access model portion of our update here. And we made some progress on getting buy-in from the various community groups to define what reasonable access is. It's not defined in the temporary specification. In our experience and the experience of a number of law enforcement agencies, security professionals, has been that there is no reasonable access right now, and registrars are just too afraid of the fines that they face under GDPR to provide reasonable access. So we made good progress in working with registrars, registries, and those intellectual property security professionals and law enforcement to get closer to an idea of what reasonable access might mean. So thank you for popping up the timeline here. We are just slightly behind schedule on the EPDP initial report. It was ideally to be published pre-Barcelona meeting, but the team is nearly in a position to have that drafted, and our customers will certainly hear from us when that happens, and we'll be open to ideas for commenting on the initial report. So I think now we're headed back to you, Staten, for that unified access model update.
Yes, thanks, Brian, very much. As I mentioned, there's a lot of different GDPR and WHOIS related strategies and approaches going on. The first, which Brian just reviewed for you, was the sort of the policy work that's happening. But there's also some multi-stakeholder engagement work happening around what's called a unified access model. So this is hopefully, well, conceptually, the long-term solution to how parties that have a legitimate interest in seeing registrant data will gain access to the data going forward. And ICANN, back in June, threw out an initial framework for such an access model, which outlined a number of different elements. And this has gone through a review and comment period, and a second revised framework was published back in August. And other comments have been solicited from the community on this. The UAM, as we refer to it, has 5 important elements. It has a definition of the kind of groups that would be eligible to receive access of the data. It prescribes a method and process for authenticating such groups. It would identify which body or bodies would be the repository or provider of the registrant data after authentication had been made. It would determine the scope of the data that would be shared with the requesting party. And it would also include a list of safeguards that would be implemented to protect the data from misuse or unauthorized disclosure. What was significant in Barcelona was that ICANN signaled a willingness to explore the possibility of becoming the central repository for the WHOIS data. And that's important because under GDPR, if ICANN were to become the repository of registrant data and would be the body that would share that data to any accredited party, they would become what's called under GDPR, or what's referred to and defined under GDPR as a data controller. And by assuming that role, and with registrars and registries simply passing registrant data to ICANN pursuant to a contractual obligation, the liability and risk to registrars and registries would be reduced, which is certainly appealing to registrars and registries. And we saw at ICANN registrars, registries, and the IP protection advocates and community all generally supporting the notion of ICANN assuming this liability as the central repository, sometimes referred to as the hub and spoke model, which simply means ICANN is at the center of where registries and registrars submit the registrant data to ICANN, and then parties that have a legitimate interest, a limited purpose, and a legal basis for looking at that data will can seek to have access to that data. So that again is where we all hope the work in the multi-stakeholder community will lead for a long-term solution to allow for access to this important data. And as we move forward away from GDPR, I'll just add the third strategy and approach that MarkMonitor and others are engaging in is a cooperative engagement approach with registrars and registries directly to learn from them what information or data do we need to provide when we make a request for that WHOIS data, even today. And so that effort is an important third-prong approach to the GDPR and WHOIS issue, which is in the short term, while we get through the policy and we get through the multi-stakeholder engagement around a unified access model, what can we do today to get that WHOIS access? And the only way that we believe there's success is to directly engage with registries and registrars on what makes them feel comfortable in terms of a request. So as we leave GDPR, I'm going to hand it over to Brian, who will provide some updates on some other policy making that happened during ICANN, I think, which will be of interest.
Sure. Thank you, Staten. And for our listeners today, if you're tired of hearing about GDPR, now's the time to tune back in, because now we're talking about other stuff. So there are things other than GDPR, believe it or not, that are happening at ICANN, and we think it's important to provide an update on everything that's happening. So the Rights Protection Mechanisms Working Group has been busy, and this group is nearing publication of its initial report. Right now, the group is focused on the URS, and the Rights Protection Mechanism Working Group has already taken a look at the TMCH and Sunrise phases and these other mechanisms that allow brand owners to protect themselves and their customers in the new GTLD sphere. This current phase is focused on new GTLDs, and then the next phase will tackle the UDRP, which is sure to be contentious with lots of fireworks. So progress in Barcelona was made by this group on deciding what would go into the initial report and what standards would be applied to the comments or the opinions presented by members of the working group as to what should be included. And there was some discussion about the best way to include comments in the initial report. And at the end of the day, the group will take most every comment that was submitted to the working group as part of the initial assessment of TMCH, Sunrise Phase, and URS, and those will be published in the initial report, which again we encourage our customers to comment on to the extent that you're interested in rights protection mechanism online, and that's a lot of our customers. And if you'd like some more information on rights protection mechanisms available to you in new GTLD specifically, shameless plug for the webinar that I'll be hosting with Doug Eisenberg on November 6th, where we'll cover in-depth rights protection mechanisms and best practices for brand protection utilizing those rights protection mechanisms. So if we go to the next slide, the other thing that's happening at ICANN that's not tied to GDPR is subsequent procedures. And Staten mentioned earlier, this is the group that's doing a wholesale review of round one of the new GTLD program and considering any and all changes that should be made to the program to enable a round two to occur. So this group was broken up into over 40 distinct topics. There's a lot that went into round one, including the guidebook itself, the application process, legal and regulatory, the contracts, dealing with ICANN compliance. Can registry operators have generic terms to the right of the dot and close them off for their own exclusive use? And then the other piece that was lumped in with what are called work tracks 1 through 4 is the technical and operational considerations. So how do we know this isn't going to break the internet? What assurances do we need to give to those concerned that adding new TLDs isn't going to break everything? Very real concern for some, and so the group needs to review those. The fifth work track that was split off from this is going to take a bit longer, and that work track is focused on geographic names at the top level. So the update from the work tracks 1 through 4 were just basically questions about how long this should take and process to get to the next level. I think that there are questions in the community about why this is taking so long and what can be done. And following the initial report published by the working group on work tracks 1 through 4, there was a public comment period, and those questions are being distilled now into consideration into 3 different groups within the subsequent procedures working group, and then those will be published later. So work track 5 is another interesting one, a bit different from the rest of it. It's specific to the geographic names to the right of the dot. So the update here is that there's still, as there has been throughout the new GTLD program, real support for continuing to reserve country names to the right of the dot. Right, no private group should be able to apply for .Italy, for example. That seems to be generally agreed upon in the ICANN ecosystem, and that extends to capital city names as well. Now, where we've seen some fuzzy area and some difference of opinion is in 3-character strings. So we know CCTLDs are 2-character strings, like .us has to belong to the US government. But it gets a little fuzzier, and folks start to disagree when you talk about 3-character strings and then city names that are not capital city names. And it seemed to be that the intended use of those city names or strings that could match a city name was going to be important to the evaluation of those strings as to whether they should be viable and should be available for a top-level domain going forward. So updated timeline. The goal is to have the initial report for this Work Track 5 out in the next month, and that's slipped a bit from the initial estimate, but ideally then that would make the complete report from Work Tracks 1 through 5, and then there will be a comment period on that, and then this will work its way through the rest of the ICANN policy mechanisms. It needs to go to the GNSO Council and then go to the board, and there are some other dependencies here. There's some outstanding work from the Security and Stability Advisory Committee on name collision and a couple of other things that will need to be addressed before we can get to a round 2. So if we can move forward one more. The other thing that MarkMonitor worked on in Barcelona was some .brand work. And so as a member of the Brand Registry Group, we participated in the Brands and Domains event. And it was a really good event and a good opportunity to share some thought leadership and to hear from other thought leaders in the .brand space. We talked about key lessons learned over 5 years of .brands, how to launch, how not to launch, some things to do, how to work with internal stakeholders. We know a number of our customers are in legal and in the legal department within your organizations, and we found some success in working with helping our customers work with other departments like digital marketing and risk and info security to really get traction with your .brand TLD. So there was some interesting conversation too about the HSTS preloading, which essentially means that you are able to tell Google Chrome, Firefox, Safari, Internet Explorer, Edge, that if any domain name is queried in the browser bar by a user using that browser, that it must be served over HTTPS. And so it's a way to force security across your entire TLD. And there's some really interesting concepts about what that can do to your security. And Google's really encouraging it. So while no one will tell you with a straight face that that's going to be a magic potion or a silver bullet for search engine optimization, it's a good idea, generally speaking, to do things that Google is encouraging you to do, especially as they've shown a preference for secure sites. So that's an interesting concept that we're happy to discuss with our customers who have questions about it. I think with that said, we're back to Staten with other topics. Yep, here we go.
Great, Brian. Thanks so much. And thanks to you and other members of the team that slogged it out in these policy working groups at ICANN, the subsequent procedures working group, the RPM working groups. There's a lot of important work there that has to be done and has to be completed before the next GTLD round or .brand round or whatever the round is coming up next. Focus is always there at every ICANN meeting. I would like to do a couple of quick hits here for you on some other things that probably don't deserve a slide in and unto themselves, but certainly things that we're keeping an eye on and think would be of interest to those of you on the webinar today. The first thing I noted there was that the ICANN board passed during its board meeting held in Barcelona a resolution directing ICANN's president and CEO, Joran Marby, to remove the do not proceed classification, which was pending on Amazon's application for .amazon. That will trigger now a resumption of the processing of the application and moving it forward to a potential resolution of the dispute around .amazon. For those of you who had joined us in previous webinars, we did mention that, of course, the issue with .amazon is that several members of the GAC who are representing countries that are in the Amazon region had concerns and objections to the .amazon top-level domain name. And for the last several years, ICANN, as well as Amazon and the GAC, have been working through these concerns, and in the meantime, the application has been essentially frozen. But this ICANN board resolution this past week, signals that there has been some progress being made among the interested parties, and that an outcome and resolution is going down that path. So we'll see. ICANN also announced proposals to replenish its depleted reserve funds. The reserve fund was heavy after the first GTLD round, with with several funds to the coffers made by applicants for new top-level domain names. But since that time, the reserve fund is depleted. The community is putting forward proposals, as well as the ICANN itself, on how to replenish these funds. And there are some community members that are proposing that the auction proceeds from the first TLD round be used in part for replenishment. So we're watching that as well. Speaking of the next round, unfortunately for those clients who are anxious to or interested in getting their .brand, we're still years away. But community members are starting to coalesce around a couple of ideas on how to expedite that process. Of course, the work of the subsequent procedures and the rights protection mechanism and other review groups must near completion before any new round can be launched. But to try to move ICANN in the direction of preparation, the community members are throwing out proposals for the next round, maybe one that is done in phases, with a .brand or a .geo top-level domain name going first, as those are less likely to be contentious in terms of their application process, so a very much more simplified process. But this is certainly not policy by any stretch. It's simply a proposal that's being socialized among parties within the ICANN community, but we'll see how that goes. Also, I thought of interest at this ICANN meeting were some attendees, some vendors, and other organizations that were showing some innovation in the space by showing how domain names can be used in ways other than the conventional naming on the internet. Some of these include some blockchain applications or geolocation activity, and some new cybersecurity methods. So as someone who's been in the domain name industry for over a decade, I find innovation, glimpses of innovation, very interesting and exciting, because often people accuse our industry of not being as innovative as it could be. But as I said, I'm really delighted to see some innovation happening in the space in recent months. And finally, I mentioned the ICANN board making a decision to defer ThickWhois implementation for VeriSign's TLDs. For those of you who are unfamiliar with the term ThickWhois or ThinWhois, ThinWhois data only includes the name and certain creation date. It doesn't include any registrant data. ThickWhois information data, though, does include registrant contact information. And in the wake of GDPR and the WHOIS and the EPDP, the ICANN board saw fit to just defer any requirements for ThickWhois implementation for VeriSign, at least for the near future. So those are the quick hits of some other things that I thought were important to raise to the audience. The last slide before we go to questions is one that I include during every webinar, which is how you all can get more involved in ICANN if you're interested. We are members, MarkMonitor is a member of the business constituency, the intellectual property constituency, as well as the Registrar Stakeholder Constituency. We are also members of the Brand Registry Group and the Domain Name Association. The DNA is, of course, the trade association that represents those who are in the business of selling and provisioning domain names, the Brand Registry Group being the organization that Brian spoke about earlier, which is fostering innovation and best practices among those who have a .brand, top-level domain name. The IPC certainly is looking after our clients' intellectual property interests and how they're protected in the domain name system. The BC, similarly situated, but also looking forward to protecting brands online. So if any of you are interested in joining these groups or have any other questions about how to become more active and raise your advocacy and voice within ICANN, feel free to reach out to Brian or myself, and we'd be happy to provide you some suggestions on how to do that. The next meeting is going to be in Kobe, Japan, March 9th through the 14th. It will be a community forum format of meetings, so it's slightly smaller than the annual general meeting that occurred in Barcelona, but MarkMonitor will be in attendance there and participating again in the full schedule that the community forum format has dictated. So we're looking forward to visiting our friends in Asia and being in Kobe. And with that, we're happy to take some questions. So I'll invite Brian Costello, our moderator, to spin up the queue and fire away at us. Brian?
Thanks, Staten. Looks like you got some Kobe beef coming to you in your future here real soon.
I certainly hope so. I hope so.
Looking forward to it.
Yeah, so thank you, Staten and Brian, for a great presentation. As promised, we will take the next 10 minutes to answer your questions. If you have a question for either Staten or Brian, please type them into the Q&A or chat windows available at the bottom of the WebEx platform. Also, please be reminded if we don't get to your question during today's Q&A session, we'll be sure to follow up with you afterwards. So our first question is, when does MarkMonitor think the next GTLD round will occur?
Brian, you want to take that question since you sat in the .brand sessions? That would be great.
Sure. Yeah, the short answer is not next year. We know that there's, looking at the ICANN budget for next year, there's not budget to support a new GTLD round in 2019. I think that it's possible for 2020, but I would caution even that much optimism because, as we mentioned, there is quite a bit of work still to do from the subsequent procedures working group, and that working group, if it can come to consensus on the changes that are appropriate or prudent for the next round, that working group needs to publish a final report. And then the GNSO Council needs to approve it, and then the ICANN board needs to approve and adopt that at the next meeting. And each of those steps is going to take at least a month to get on the agenda for the next meeting of the layer of bureaucracy. And at that point, it will need to be scheduled, and the policy will need to be implemented before it can happen. So realistically, I would say that probably 2021 would be the earliest that companies will be able to apply, and I know that's disappointing to some of our customers. And I'd note that that MarkMonitor's policy position on this is that with strong rights protection mechanisms available for our customers to help protect their customers in the open new GTLDs, we think that the .brand TLDs do not require the same, don't warrant the same kinds of concerns from the community, and the .brand TLDs should be able to comfortably go sooner than others, and we support the folks in the industry that are pushing for an earlier .brand round if that's possible. So we do support an earlier round, but realistically, not next year and probably not in 2020.
And I'll just add, Brian, that for those clients who are interested in a .brand, if you haven't already kind of communicated that to our team, it would be good for us to know. Certainly, we would never share or disclose your intentions publicly, but for us, it helps in understanding the level of demand, and also would be curious to know whether you support, a kind of a phased approach to the next round, as we explained, with brands going first, or geos, or something else. So if you're able to provide us with some feedback on that, that will help us in our advocacy efforts.
Okay, great. And our next question, so if the attendees were interested in applying in the next GTLD round, what should they be doing now to prepare for that?
Well, I'll take this one, and then Brian can follow up with any other suggestions. But
sure.
I think what we're seeing in the conversations that we're having with current .brand owners is, trying to increase the level of awareness so that future applicants can see what is being currently done with a .brand, and what possibilities there are, and what successes we've seen to date. So if I were an applicant, I would suggest that you look at a couple of websites. One of them is makeway.world that showcases what some of the other brands are doing with their top-level domain name. And you can see how they're provisioning it, how they're using it for marketing campaigns, for communication with their clients, and that will give you some ideas of how you would like to shape your own strategy for your .brand in the future rounds.
Yeah, thanks, Staten. And I would just add that in addition to coming up with use cases for your company, which you may already have if you've decided that you're interested in the next round, you should think about, from a pragmatic perspective, deciding which legal entity you own that will be the new GTLD applicant. Speaking from experience in the first round, some companies were not prepared to list personal information about the officers and directors of the legal entity that they chose to apply, and some applicants were not comfortable producing the financial statements of the entity that they used to apply. And just remember that ICANN takes very seriously their responsibility to coordinate the DNS, and won't allocate a string to you to the right of the dot without doing a considerable amount of due diligence. So for publicly traded companies, this is probably no problem, but if your organization or the legal entity that you're going to use to apply is not publicly traded, or might have some issues with producing that kind of information, you should think about which legal entity you'll use to apply, including which one owns your intellectual property, because .brand TLDs get special rules by virtue of owning intellectual property, and that may need to be owned by the legal entity that applies. So we're happy to discuss that further, and it's a little bit early because we don't know that the policy for the next round will be exactly the same as the first, but we're happy to have those conversations with customers that have specific questions.
Okay, great. Next question from one of our attendees: how do GDPR and California compare? Anticipated impact of compliance efforts in California on WHOIS?
Well, great question. Unfortunately, I haven't read the California state privacy law, so I can't speak to too many of the. So I can't do a comparison that would be probably as helpful as I could. But I do want to take this question as an opportunity to talk about what we're seeing in terms of future privacy law, I think those of us who have been absorbed in GDPR for the last, at least a year, as it has impacted the domain name industry, but obviously longer, that this is not going to be the end of privacy legislation. And so what we need to do as a community is come up with policies that would be accommodating for future privacy laws, whether they be laws that are enacted in the United States or laws that are acted in other participating global regions. And I think the fact that California has been one of the first out of the gate to legislate privacy within its state borders, I think that speaks to a trend that will be growing in the future, where states and other countries will be enacting privacy legislation that we're going to have to be responsive to, which again, I think means that our strategy that we're following at MarkMonitor related to participation in policy development, participation in multi-stakeholder activities, and participation in a cooperative engagement approach to solving who is issues and making sure that everybody's GDPR or data protection compliant is important. And we'll see what is on the horizon, but I'm almost certain that we'll see more privacy legislation.
I'd agree with that, Staten, and I would just add that while I also haven't read the black letter law in California, we are mindful of the California effect, so to speak, on these kinds of things, where we look at a parallel to automobile emissions and automobile manufacturers deciding not to make a California-specific model, but rather just make all of their vehicles compliant with the tougher regulations. So we're looking out for parallels in how our customers should expect that to, or if they should expect that to extrapolate to other states or to federal legislation. And so we have an eye on it.
Okay, great. And our final question for today, how bad is the problem that WHOIS data is mostly unavailable now? What can ICANN do about it, and what can MarkMonitor do about it?
That's a great question, and there's a lot of elements to that. So just last week, MarkMonitor published a blog post that I had written that shows some preliminary data that Brian actually gets credit for herding for us and doing some analysis for us, that shows the impact of redacted WHOIS on our ability to do brand protection. Not surprisingly, it does have a tremendous impact on our levels of efficiency to do brand protection. We have, and I've mentioned this in previous webinars, we have implemented some mitigation measures to alleviate that impact by adding more brand analysts to our team, because in order to determine who the registrant is going to require more manual research. So we've added staff to help us with our enforcement efforts. We've also deployed a technology that helps us look at websites to determine if there's any contact information on those websites that we could use to either identify who the registrant is, or at least be able to figure out how to communicate with a registrant in the wake of not having WHOIS data available. So there are ways to cope in this environment. I had in a previous blog post as well, we provided some tips and a toolkit for our clients to help them request that data and where to look for alternative pieces of data that will help them do their enforcement efforts. And if the person who asked the question would like to submit their email to me, I'm happy to send them links to those blog posts so that you have that information, or anybody else on the call who'd be interested in that. These are blog posts that have been made public, so we're happy to share our data and also any information that we feel would be beneficial to our clients to help them navigate through this post-GDPR environment.
Thanks, Staten. And if I could add, thank you for the shout out. And I couldn't have done it without Ross Jensen from our brand team. So special thanks to Ross to help analyze that data. And I think part of the question was, what can ICANN do about it? And ICANN, the organization, when you think about ICANN, you think of like the people that work in the building, and then ICANN, the community and the multi-stakeholder model. So ICANN, the organization, has expressed a willingness to facilitate conversations about unified access, but is largely letting the community in the multi-stakeholder bottom-up EPDP decide how whose data is going to look and how access will be provisioned going forward. And I would just add that from the ICANN perspective, and Staten covered what MarkMonitor is doing about it.
Great. Thank you, Brian, and thank you, Staten. Great presentation, and thank you to all of our attendees for attending ICANN63 recap updates from Barcelona. We urge you to take a few minutes to complete our brief survey, which will automatically appear as you exit the webinar. You will also receive an email after the broadcast with a link to the recording and to download the slides. With that, we will end our presentation today. Have a great day. Goodbye.